Ladies and gentlemen, we continue our program, and the program now provides for a session in which two distinguished speakers are invited to speak. I ask Mrs. Anna Siegel and Mr. Jan Schellisen to sit here at the podium so that they can give their presentations. The subject we are going to deal with is private law rules as implementation tools for international policies. And our distinguished speakers are Ms. Anna Siegel, who's legal advisor and director of the Office of International Standards and Legal Affairs, United Nations Educational, Scientific and Cultural Organization, UNESCO. And then Mr. Jan Schellisen, I'm sorry for the pronunciation, wrong pronunciation before, Director of the Information Society and Action Against Crime Directorate, Council of Europe. Mrs. Siegel, you have the floor.
Good morning. Well, I'm sorry to be substituting for your coffee break. I'm sure you thought you might get some coffee before we moved on to the next break. But we both have quite strict time limits, so coffee will await you in half an hour or so. Now, I have been asked to talk together with Jan about private law rules as implementation tools for international policies. Obviously, I'm talking in the field of cultural property, and I think Jan in the field of corruption-related measures. First, I wanted to quickly thank the organization for the invitation and congratulate it for its 90th anniversary. UNESCO had our 70th anniversary last year, and I think it's quite interesting that UNESCO and UNIDROIT do quite a lot of cooperation together and have for many years in the field of cultural property. Now, as the topic is how do we use private law rules, that being obviously the focus of UNIDROIT's work in uniformization of private law rules. But I also wanted to look at the first side of the equation, which is the international policy concerns. UNESCO has a significant mandate in the field of protection of cultural property. It's become probably a much more political and visible issue in the wake of recent events in Syria, Iraq, Yemen. As a number of the early speakers mentioned, I was interested that both the representative of the Italian government and the representative of the Greek government specifically mentioned the cooperation between UNESCO and UNIDROIT. Now, if you look at the First World War and the Second World War, I think the destruction and devastation caused in those conflicts with the increasingly mechanized means of pursuing war led to increasing destruction of cultural property and an increasing consciousness that protection of cultural property is important both for the identity of nations and individuals and for the protection of the common cultural heritage of all citizens. And then I think if you look in the 1960s and perhaps particularly with the move towards the end of colonization, there was an increasing awareness that items of cultural property had been taken from a variety of countries which had been colonized. And then I think ongoing occupations have also led to concerns about protection of cultural property. I think those two elements led to a number of developments in international law. I mean, in international law governing armed conflict, the 1954 Cultural Heritage Convention specifically and explicitly provides that cultural objects are not to be the object of attack, which is obviously simply a further development of the requirement under international law of armed conflict that there be a distinction made between military and civilian objects. The convention, I've had to get my other glasses repaired so I can either see you or the paper, not both at the same time. The 1970 convention, the UNESCO Convention on Protection of Cultural Heritage, deals essentially with illicit transfer of cultural property with a notion that there needed to be return. There's also, just for completeness, there's a 2001 Convention on Protection of Cultural Heritage, underwater cultural heritage, that's been there for longer than 100 years. And the notion there is also that that cultural property needs to be preserved for the cultural benefit of the country in which it's located and shouldn't be stored on the international art market. I think probably another development which has made it more important to deal with illicit trafficking in cultural heritage has been the development of a number of the internet, of a number of internet, eBay, and other auction house internet activities where it's much harder to control that which is sold on the internet, and makes it increasingly important to have proper requirements and restrictions on export of objects requiring export certificates and the like. Now, I was struck yesterday that the Secretary General of UNIDROIT mentioned that the League had requested and consulted explicitly with UNIDROIT to work on development of law in specific areas. And this is what happened between UNESCO and UNIDROIT in the early 1990s. There was a feeling that there was a certain gap in the framework for preventing illicit trafficking in archaeological and other cultural objects, because of the state-to-state nature, if you like, of claims which could be made pursuant to the 1970 Convention. And it was at that stage decided that it would be helpful for the two institutions to work closely on developing a convention that would apply in the private legal system. So after some years of work and experts meetings and drafting groups, the 1995 Convention on illicit trafficking, export, import, illicit trafficking of cultural property, cultural objects, was adopted. Interestingly, and not surprisingly, the two conventions adopt the same definition of cultural objects. It's property which on religious or secular grounds has been designated as important for archaeology, prehistory, history, literature, art, science, and is in one of the listed categories of objects. Now, there's a lot of sorts of objects that are protected, a lot of types of objects that are listed, and the interesting thing, as mentioned by the Greek ambassador this morning, the Convention explicitly provides for restitution of stolen cultural objects and return of illegally exported cultural objects, and it provides that this can happen directly through the local courts. So in the case of stolen objects, that can be pursued by an individual in the local courts. In the case of illegally exported objects, that's a matter that the state would pursue. There are quite clear time limits set, 3 years from the time at which the owner should have known or knew or had information to know about the theft or the export and the identity of the location where the objects are now to be found, and then a 50 years maximum limitation. What's quite interestingly different between the 1970 UNESCO Convention and the 1995 UNIDROIT Convention is that the UNESCO Convention applied specifically to stolen or illegally exported items that had been inventoried. The 1995 Convention is much broader. It applies to stolen or illegally exported items regardless of whether they've been specifically inventoried in a museum or another organization's inventory structure. One of the other points that I think is quite important to mention from a legal perspective, and this was also mentioned by the Greek ambassador this morning, but I wanted just to come back to it, is the reversal of the onus or the burden of proof on the possessor. Now, this happens in a sense in two ways. If you look at the 1954 convention which applies in armed conflict and requires return after occupation of property stolen during an armed conflict or occupation. There's a provision for compensation for holders in good faith. If you look at the 1970 convention, there's a provision about compensation for innocent purchasers or persons with valid title. If you look at the 1995 language, it's much stricter, and the possessor to be able to benefit from compensation should neither know nor reasonably be expected to have known that the object was stolen, and in addition, and this is, I think, particularly interesting, needs to have proved that he or she exercised due diligence at the time they acquired the item. Now, the treaty actually sets out a set of things that would be taken into account in determining due diligence by the possessor of an item. So you would look at the price that was paid, you'd look at the character of the parties, you would look at whether the person had appropriately consulted registers of stolen items. I'll come back to some of those practical implementation measures later. And also whether the possessor had consulted other relevant documents and information or accessed appropriate agencies which might have information about goods that might have been stolen. Another provision that was mentioned this morning was the UNESCO UNIDROIT model provisions on state ownership in relation explicitly and exclusively to undiscovered cultural objects. Because the 1995 convention is premised on the notion of restitution or return of stolen or illegally exported items, there was something of a gap, because if items hadn't been discovered because they were in the ground or a dig hadn't started, how could the state then say that they belonged to the state so that they could pursue recovery in domestic courts? So the notion of the work that was carried out jointly again by UNESCO and UNIDROIT was to look at unexcavated items and essentially to develop some model language for model provisions in laws which countries could themselves adopt, which would essentially say that if they're undiscovered cultural objects, they're owned by the state. And in addition, and that anything which has been either illegally excavated or legally excavated but subsequently illegally retained would also be deemed to be stolen. So the way in which a country can get access to that which is not yet discovered, should it be stolen prior to discovery, is through this mechanism, should states choose to do that. Now, obviously this is particularly important, and I think will become increasingly important. And I think with the looting and destruction that we're seeing in the Syria context and have seen in Iraq and have seen in Yemen, it's also behoven on countries in where there are significant art markets to assure that they take proper measures to ensure that nothing that they sell in their online systems may have been illicitly or improperly exported or purchased or transferred in any way. I wanted, after setting out a little bit the legal framework, I wanted to just mention a few of the practical things that states have adopted to try to improve the capacity to restrict the trade in illicit and stolen cultural objects. But first I wanted to make a point about ratification, and I think it's something that's very important. The 1995 convention is much less ratified than the 1970 convention. In fact, interestingly, at the time we were working on developing the 95 convention, there was a significant spike in ratifications of the 1970 convention, but at the moment, there's, I think, over 130 ratifications for the 1970 UNESCO convention and only 37, I think, though some are in the pipeline, of the 1995 convention. So it is something that I would call on those government representatives who are here today to check the extent to which they're parties to both of those treaties. Both of them are important and they're complementary. There's a couple of other systems for trying to deal with questions of illicit export, transport, transfer and theft of cultural objects. There's a specific European set of directives and regulations which will apply between all EU member states and is legally binding. There's also a Commonwealth system which will apply between the 53 Commonwealth member states, but will depend whether implementing legislation has been appropriately adopted in the particular Commonwealth state. A few other practical tools which I wanted to draw your attention to before closing. Obviously, to limit illegal export and import, a good system of export certificates and requiring export certificates is important. UNESCO and the World Culture Organization have developed a model export certificate which has quite good take-up, but is, I think, another useful tool. UNESCO has a quite large database with a lot of information about the cultural heritage protection rules of its 195 now member states, with some 3,000 pieces of legislation. So if you're wanting to trace legislation and see whether it's been exported illegally from another country, then there's legislation that can be easily consulted. We worked at UNESCO on developing a code of ethics for dealers in 1999, and that's something that we're trying to encourage art dealers to sign up to. The International Council of Museums worked on a code of ethics for museums in 2004, and that has quite good buy-in from museums. Another very valuable couple of tools is the International Council of Museums has a so-called red list, which indicates, particularly in some of the countries most at risk at the moment, Syria, Lebanon, Iraq, Yemen, and others in the Middle East, items that are likely to be appearing having been illegally exported. Interpol also has a stolen works of art database which can be consulted by police authorities, and they've also developed an object ID so that where something has been stolen or lost, you can identify it with 9 characteristics and it's easier to trace it. So those are the practical measures that have been developed by a variety of organisations working in the field of cultural heritage protection. The last thing I wanted to mention was UN Security Council Resolution 2199, which was also mentioned this morning, which explicitly raises and draws concerns to the destruction of cultural property in recent conflicts. It explicitly makes a link with income being generated from looting and sale of cultural objects from Syria and Iraq, and calls on states to take all efforts to prevent that trade, the link being made with increased capacity to carry out terrorist operations and increased finances for recruiting in these contexts. And has explicitly called on UNESCO to provide assistance also in taking note of the measures that countries are adopting, both the neighbouring states to the Syrian conflict and also other countries. I would like to close with that small overview, and thank you very much for your attention.
Thank you very much to Mrs. Siegel for her comprehensive and very interesting overall view over the various tools of public international law and private law dealing with the protection of cultural heritage. We now will have the pleasure of listening Mr. Jan Kleijsen, who will speak on the same general subject, but I believe on matters other than cultural heritage.
Thank you very much, Chairman. Being the last person to stand between the audience and especially Italian coffee is, I think, a considerable challenge. So I would just like you to crave your indulgence and ask you to bear with me for a couple of minutes. I represent the Council of Europe, which is, with its 47 members and a mere 67 years of existence, a sprinkling in comparison to UNIDROIT. But like UNIDROIT, we work on a number of issues through conventions, binding conventions. And Chairman, although I was asked to speak about corruption, let me also start with cultural property for a moment, because the organization I represent, the Council of Europe, is all about human rights, democracy and the rule of law, and in that context has been dealing with terrorism since especially 9/11, but also, of course, in wake of the recent events. Following United Nations Security Resolution 2198, we provided a convention against, or a protocol rather, to our convention on terrorism regarding foreign terrorist fighters, which we negotiated in 7 weeks, and which may be the fastest legal instrument ever concluded. Usually we take years to negotiate a convention, and I think 7 weeks was a pretty good show. We have some nearly 30 signatures, we hope early ratifications. But 2199 was mentioned several times, by several speakers this morning. We've just received a mandate from our governments to negotiate a treaty, a convention this time. It will take a little bit longer than 7 weeks, but to complement the UNIDROIT and UNESCO conventions in the criminal field. We will be drafting a criminal law convention on the trafficking and cross-border trade in looted and stolen cultural goods. And we hope that in doing so, together with the instruments that were already mentioned, we will be able to more effectively tackle the likes of Daesh, for whom this has become a major way of financing their terrorist activities. We will, of course, associate both UNESCO and UNIDROIT with our ongoing negotiations, which will start formally in June. Now, Chair, then, as promised, let me turn to the question of corruption, which I think is a crossroads between private and public law. For us, obviously, corruption threatens the basic principles we stand for. It threatens rule of law, stability of democratic institutions, and human rights. We try to tackle corruption from a multidisciplinary angle, that is to say, to deal with the criminal, civil, and administrative law aspects of it. 2 conventions, which I would like to briefly discuss with you, were established. The first is the Criminal Law Convention on Corruption of 1999, which has a protocol of 2003, ratified by nearly all Council of Europe member states, and a Civil Law Convention of the same year, which has been ratified by about 2/3 of our membership. To start with the Criminal Law Convention of Corruption, but it has important links also with private law, as I'll try to demonstrate in a moment. It refers to a range of criminal behavior which countries are required to criminalize: bribery, trading in influence, money laundering, and account offenses. It addresses the passive and active forms of certain offenses, such as bribery, corrupt acts involving public officials, and those involving private sector entities. The protocol, which I already mentioned, of 2003, extends the scope of bribery to other categories of persons, including those involved in arbitration. By addressing private sector bribery, the Convention seeks not only to ensure fair business practice and competition, but what it also does is try to preserve certain public interests related to public health, consumer protection, and the environment. That this is very topical was demonstrated earlier this year. Reports in the Irish and British press that a certain famous high-tech company employees from a certain high-tech company in Ireland had been offered up to 2,000 euros in bribes to pass their login IDs to hackers. And it is easy to imagine what the results of that could have been. It is an example where a famous company, the logo is particularly famous, it reminds one of a fruit, becomes the target of corruption from the outside. An important feature of the convention, which contributes to new developments in a number of branches of private law, namely business and commercial law, civil law, labor law, as well as business management, is that the state parties need to establish a mechanism to hold legal entities liable for bribery, trading in influence, and money laundering. The object of corporate liability is thus to facilitate the prosecution of corruption. It envisages two situations in which legal entities can be held liable. The first is where the offense, you see I need my coffee as well, where the offense is committed for the benefit of the entity by a person holding senior managerial responsibilities, power of representation, or the authority to take decisions, or to exercise control within the entity. And the second situation refers to cases where the commission of the criminal act is facilitated by lack of supervision of control of management, so by omission. In 2006, there was a major case that you may be aware of, where a German manufacturer of electronics was massively involved in corrupt and fraudulent dealings. Criminal proceedings were brought both in Germany and in other countries, such as the United States, and involved some 300 serving or former staff members. In the end, the company had to pay fines in an extraordinary amount, about $2 billion, part of, in some countries, a prosecution agreement. What is interesting is that the company in question rapidly drew lessons from these convictions and hired some 500 full-time compliance officers, up from 86 when the cases were brought, compliance hotlines and external ombudsman accessible worldwide and online. It also created a web portal for its employees to evaluate risks in their client and supplier interactions. And further initiatives included a launch comprehensive training and education program for staff on its anti-corruption issues specifically. I should say that also in the Council of Europe, our financial officers and everyone dealing with contracts are supposed to be trained and are trained on anti-corruption and anti-bribery policies and measures. An ever-increasing number of businesses are now introducing internal integrity and anti-corruption programs to avoid situations as I just described. The International Chamber of Commerce also has elaborated a series of guiding documents on this. And I think it is fair to say that the concept of legal risks has now become an integral part of risk-based management of entities, in addition to the commercial, financial, reputational, and other risks. Let me now say also a few words about the Civil Law Convention on Corruption. It deals with subjects which were fairly new at the time and had not yet been considered much in the context of anti-corruption policies. 3 series of standards are enshrined. First, countries are required to put in place mechanisms that allow persons to obtain full compensation for damages resulting from acts of corruption. This may cover material damage, but also loss of profit or other non-pecuniary loss. The most frequent example I can give is the loss of reputation of a competitor, which may be compensated financially or by the publication of the judgment. In principle, such internal law mechanisms provide for the right to bring civil action in corruption cases. It's still a widespread belief that bribery, because it involves secret consensual dealings, is an offence which generates no victim. We think, however, this is a misconception. Imagine just commercial and reputational damage that a car manufacturer would suffer when one of its employees were bribed by a supplier seeking to sell substandard components. The damage could even go beyond those affecting the manufacturer and have a very clear impact on third parties. For instance, customers, others involving in car accidents caused by defective components. Secondly, the Civil Law Convention also requires the introduction of legislation that allows the authorities to challenge the validity of contracts or contractual clauses which contain an element of corruption. In the same vein, a party to a contract should be granted the faculty to challenge this contract before law if the signature is the result of a corrupt act. In any event, persons who have a legitimate interest would normally be entitled to bring an action for compensation for damage resulting from any act of corruption. And thirdly, even more importantly, the Convention was one of the first international initiatives to require that employees who disclose a corrupt act, the so-called whistleblowers, be given protection against retaliation, either by the employer or by colleagues. This protection should entail, and at a very minimum, civil compensation where the whistleblower has suffered negative consequences. Practice in recent years has shown that unfortunately private entities, but also public institutions, have a tendency to sanction those who work for them when they speak up and try to alert criminal justice or the media about possible crimes or other matters of public concern. And retaliation, as we know, can take many forms, from psychological harassment, demotion, to dismissal. In addition, the subject is so topical, and many cases will come to mind that were reported in recent years, that our governments decided in 2014 to address the question of whistleblowers through a detailed recommendation complementing the convention I just mentioned on the protection of whistleblowers. And it recommends that member states have in place a normative, institutional and judicial framework to protect the whistleblower from reprisals. This has an impact also, of course, on substantive employment law in relation to contracts and protection against the dismissal I already mentioned, and other measures that could be taken against a whistleblower. Let me now conclude and say a few things about the stage of anti-corruption policies. Until some 15 years ago, a certain amount of tax-deductible expenses existed that could be linked to corruption. This is now completely changed. International corruption standards and domestic anti-corruption policies have become far more effective. It is true particularly for the public sector, but also for the private sector. Many opinion polls point out that when citizens are asked what they consider to be the major threat to the stability of their country and to their well-being, they indicate corruption in Europe, beyond Europe, a worldwide phenomenon. Therefore, the fight against corruption should be a major concern for all governments. As I've tried to illustrate, corruption can only be tackled effectively if public and private law come together and join in. It is thus that we can be most effective, and we look very much forward to continuing working with UNIDROIT in the future to be effective against this threat. Thank you very much indeed.
Thank you very much for this excellent presentation, which showed how necessary is the cooperation between the various tools that are available or that can be used for useful purposes, such as the important fight against corruption. And perhaps there is no country in Europe more than Italy that should take very seriously into account these considerations. There are no more obstacles to our coffee break. I thank you for the patience, and let's have a last round of applause for our distinguished speakers.